Hi, this is the Elections and Redistricting Committee meeting. We're waiting for members to arrive, and so just hold on for a moment. Thank you. I could start as the subcommittee. We have a Republican present, and Mr. Swanson.
Thank you, sir. Appreciate it.
Thank you. First bill is AB 413 by Yamada. Mariko Yamada. My wonderful seatmate.
All right.
Yeah.
Thank you. Good afternoon, Mr. Chairman and members. Thank you for this opportunity to present AB 413, which is a district bill. And I would first like to thank the chair and his staff for working so diligently on this iteration. This is actually the third time that I presented a bill similar to this and my third year here in office. So it should be familiar to those of you who have been with us before. But for those who are new to this committee, AB 413 would allow for a pilot program in Yolo County to conduct 3 all-mail or all-postal ballots for purposes of a study to determine what kind of outcome and behavior would be elicited by an all-mail ballot opportunity. This would not only save the taxpayers money, but it would also determine whether or not this kind of election, as we know, as is trending throughout the state in higher numbers of people choosing to vote by mail every election. We also know that in other states like Oregon, all postal ballots have been in effect for a number of years, and those voters are pretty happy and the taxpayers are happy as well. So with that, I want to turn to my colleague here from Yolo County, Tom Stanionis, who works for our elected Yolo County Clerk Recorder, Freddie Oakley, for any questions, and I would respectfully ask for your aye vote.
Okay, witnesses in support.
Tom, would you like to?
I don't know what to add to her remarks. We're in the midst of conducting an all-mail election for a school district in Yolo County, and I was just talking to her beforehand. We'd like it to be a little bit clearer in the code that we can do this. And we'd like to have some mechanisms in place to explore the consequences of doing an election as an all-mail election and whether it better serves the voters.
Thank you.
Great, thank you. Witnesses in support.
Good afternoon. My name is Dawn Abrahamson, and I'm the City Clerk for the City of Fremont and the Legislative Director for the City Clerks Association of California. I am here representing CCAC today and in support of AB 413. We support this bill for the following reasons. It will provide a cost comparison of vote-by-mail elections to traditional elections, provide data on the impact of voter turnout, help to reduce election costs and provide data to the state to support this claim. Local elections are smaller than state elections and traditionally have a lower voter turnout. Because of this, a smaller sample will allow for better data and an opportunity for a more in-depth analysis of the voter turnout and cost savings of all mail voting. For these reasons, I respectfully request your support of AB 413. Thank you.
Hi, good afternoon. Natasha Carr on behalf of the League of California Cities, also in support.
Thank you. Any other witnesses in support? Any witnesses in opposition to this bill? None? Any questions?
Thank you.
Andre?
Thank you, Mr. Yamada, for the bill again this year. Is the election code vague on county's ability to hold mail-in? Is that why you want this additional assurance?
The election code, I want to say Section 4100 of the election code, has slightly contradictory elements in it that for our current election, the district lawyers have been pretty persistent in saying that it allows them to do it. Our lawyers are not necessarily in agreement. We in the election business would prefer the code to be black and white, and this would give us a clear right to conduct elections like this. And if this works out, at some point the code would be much clearer to allow for these kind of elections in the future.
Sure. Thank you very much.
Thank you, Mr. Swanson.
Thank you. Any other questions? Well, thank you for doing this again. I mean, and Yolo County for being the guinea pig on this
That's right.
matter.
Thank
But we do need to find some data to see if vote by mails do work, and I really appreciate your efforts in going through and to find this out for us.
Thank
and
you.
so the amendments outline comment number 4 of the analysis would clarify the voter can get a replacement ballot at a polling place for any reason and requires polling places to be open from 7 a.m. to 8 p.m.
Yes,
You
and
accept those amendments?
we thank you very much for the hard work on it. We do accept the committee amendments. Makes the bill much better.
Great. Well, this is a great bill, and I'm fully recommending support of this bill.
Thank you very much. We hope if we're successful in getting this bill to the governor again, we know that the current governor has already expressed some interest in all mail balloting. So thank you very much,
Great.
committee
Thank you.
members. Thank you.
Thank you.
Hey, Mr. Chairman, when we get a quorum, I'm prepared to.
Yeah, when we get a
vote the bill.
quorum, we'll take it up. Assemblymember Knight?
Yes, AB 193.
Okay. AB 193. Assemblymember Knight?
Pays to stick around.
Great. Yep.
Well, good afternoon, Mr. Chair and members. My bill, AB 193, talks about polling places. Existing law provides requirements for local election officials to designate public and private properties and facilities for use as polling places. But currently, registered sex offenders in California can hold a polling site at their residence. I think it is fair to say that most Californians aren't even aware that this is taking place today. This measure is common sense and provides an additional layer of protection to high school volunteers on Election Day, as well as children that accompany their parents when they go to vote. Several articles published this past summer outlined the discovery of polling locations in the Bay Area being at the residence of registered sex offenders, which is where this idea was brought to my attention. AB 193 is necessary to ensure public safety and protect voters and their children at the ballot box. Election officials will simply consult the Department of Justice's database for registered sex offenders prior to designating any location, a polling place at a single-family home. In an effort to address the concerns of the California Association of Election Officials and committee staff, I would like to propose amendments to limit the local election officials to consult the sex offenders database to only single-family homes, removing many apartment complexes that would have otherwise been included in this search. The amendment makes this bill very clear. We're talking about single-family residents, and I ask for your support.
Great. Any other witnesses in support? Concerns. Okay. Witnesses in opposition? Or you're kind of in between?
We're a tweener, yeah.
Middle.
Okay. All right.
Mr. Chairman and members, Barry Brokaw on behalf of the county elections officials. We appreciate the amendments that Mr. Knight has made. We raised several issues with this bill. But basically, it's very difficult to find polling places. In L.A. County alone, there are 5,000 of them. So just culling through the database to deal with the issue made it very difficult for us. The bill has been narrowed. We still, will not support the measure at this point in time, but we look forward to working with the author if the bill moves forward to deal with some of the other technical issues that are there.
All right. Any questions? Okay.
Are there many other technical issues that could possibly be associated with the single?
No, Mr. Swanson, about 10% of the polling places that are used in the state are single-family homes.
Okay.
So, and some counties are more than that. And some of the counties that are more than that, it poses a little different dynamic for those county registrars, trying to make sure they have enough places that will meet with the Disabilities Act and other provisions that need to be considered. So, those are the principal issues that we have outstanding.
But it's no objection to the concept that these homes should should have this stipulation? I mean,
Right. It's a lot more difficult to determine if there's a registered sex offender in an apartment or in a nursing home who may be 82 years old, and that nursing home has been used as a voting place for 40 years. So, those are the kind of issues we were dealing with before. So,
Yeah, right. Okay.
That's been removed, so
yes,
it's only
that's correct.
single-family residents.
That's correct.
Okay.
Thank you so much.
All right, thank you.
I was just curious. Thank you.
Yeah.
Well, it's a good common sense public safety measure, and I totally support your concept, and I support this bill. So when we get a quorum, we'll vote on it. And you wish to close?
Well, again, it's kind of one of those places where you expect some safety, and when you do go in to vote, you would expect that level of safety. So I think this is common sense measure.
Yeah, very good. I'll be supporting this bill.
Thank you.
Thank you. Okay. Thank you, Mr. Knight. Valadale. We need one more. AB 477 by Mr. Valadale.
Well, thank you, Mr. Chair. Good afternoon, members that are present. I'm here to present AB 477. This bill would create an exemption for vote by mail ballots cast by voters temporarily living outside the United States. The new provision would allow that these ballots be counted if they are received by the elections officials up to 14 days after Election Day, as long as they are postmarked on or before Election Day. This would impact hardworking Californians who are traveling on business overseas, studying abroad, and especially military personnel and their families who are serving our country, often risking their lives in the combat zones. California currently requires all vote-by-mail ballots be received by Election Day, yet 18 states and the District of Columbia have laws similar to that one I'm proposing that allow special absentee ballots to be counted if they are received between 3 and 21 days after the election. For example, Texas and Florida, which both face similar population size challenges as we do, have extensions on their overseas ballots. Massachusetts has a 21-day exemption, and they still manage to have successful elections. Our own Secretary of State has acknowledged that the concept does need to be addressed and sponsored a similar bill in 2009, AB 1340, by Assemblymember Lowenthal in an attempt to solve the problem. We have already established that these voters should have special consideration, and this body has improved the voting process for them by passing a measure in 2004 that allows for ballots to be returned by fax. However, military voters overseas will often go weeks or even months without being able to send or receive mail, and sometimes mail delivery will be stopped altogether if they're experiencing heavy combat. It would be pretty rare to find a fax machine in many of these instances. We just celebrated Women's History Month and are reminded that California has always been a leader in advocating for voting rights and recognizing that everyone's voice should be heard. AB 477 would make sure that the state, as a state, we have done everything possible to give our hardworking voters overseas the much-needed extra time to make sure that their vote is counted. Thank you, and I ask for your aye vote.
All right. Any witnesses in support?
Hello, Dana Nickel with Pete Conatine and Associates, representing the AMVETS, American Legion, California Association of County Veteran Service Officers, California State Commanders Veterans Council, and the Vietnam Veterans of America California State Council. All these groups are strongly in support of this. I think it goes without saying that our young men and women who are overseas fighting for our right to live in a democracy, they should be the ones to have the opportunity to have their vote counted. Thank you.
Okay. Witnesses in support?
Katie Fleming, California Common Cause, who are in support of this bill. Thank you.
Thank you. Any other witnesses in support? Okay, any witnesses in opposition to this bill? None? Questions from the?
Yeah.
Okay. Concern?
Yes.
All right.
Mr. Chairman and members, Barry Brokaw on behalf of the county elections officials. This is another bill we have some concerns with. There are a lot of implications to this affecting the final vote count that would take place. Part of the issue is that there is currently, no distinction between a special absentee ballot sent in by a military person or another special absentee ballot. They come in the same envelopes, so there's no way of determining, the difference in the voter itself. The other issues are that if we go out 14 days, we don't see any reason for specifying 14 days. We've seen bills suggesting 6 days. We've seen this bill at 14 days. But if we go out 14 days, we're going to run into a real problem in some of the counties with the canvass and getting the vote certified by that period of time.
Mr. Valadeo has taken some amendments to make it 10 days.
We haven't as of yet, but we've been looking at them.
All right. Okay. Well, we have some proposed amendments.
And what we're trying to do, Mr. Chairman, at the county level is do an assessment of when these votes come in. How many come in the day after the election? How many out day 3? How many out day 14 or out day 10? And we aren't there yet. But our concern is that if we push the election back in that sense without pushing the canvassing date out, because we have to certify the election 28 days thereafter, we're going to be really up against the gun. And if you just followed the outcome of the Attorney General's race this year, we pushed that to the very limit, counting 2.5 million absentee ballots before Ms. Harris won. And many counties had great difficulty, certifying by that 28th day. And that's with ballots that were due on the day of the election. So those are a couple of the problems that we see, and this is particularly a problem for some of the bigger counties, Los Angeles, Alameda, the major counties, Orange County. So these are concerns. We clearly understand the spirit of what Mr. Valadeo wants to do, and we certainly support the giving our military members certainly the area availability of voting, particularly if they're postmarked. And with the military postmark or an official postmark. So those are the concerns. We haven't resolved them yet. And if the bill moves forward, we certainly work with you, Mr. Valadeo.
Be happy to. One of the comments that for you to get one of the special absentee, you actually have to apply for it. And so most registrars, they do know who the people are. And so it already puts them in a different category, and it helps the locals get to the bottom of which ballots are. I mean, it's already a category. It's something they've already applied for. It's something everybody already knows who they are. We're just giving them more time to get their ballots in.
Sure. Okay. Witness in support or opposition?
For support, Lorraine Ploss, a legislative chair for American Veterans of California. We support this.
Great.
Mr. Chairman, Pete Conity representing the American Legion, the California Association of Veteran Service Officers, the California State Commanders Council, and Vietnam Veterans of America. We are all in support of this bill. And I believe Assemblywoman Lowenthal carried this bill in 2009, similar bill, and it was sponsored by the Secretary of State, if I am correct.
Right.
Thank you.
Okay, I'm going to establish a quorum now. Madam Secretary, please call roll.
Fong,
Here.
Logue, Bonilla,
Here.
Hall, Mendoza, Swanson,
Present.
Valadeo.
Here.
Okay. All right, any other questions? Sandra?
Now, does the voting ballot need to be postmarked the day of the election?
Yes, by that day, or obviously before, but up until the day of the election, has to have a postmark.
So what you're asking for is arrival time to be 14 days after. And what is it now?
It has to be in at the election department on that day.
Oh, okay. And so, and you don't think that a shorter time span is that? I misunderstood. Did you say that?
Right now we're at
it, or what are you prepared to do?
Well, it passed out of this committee here at 21 days before, and so I shortened it down to 14 to make it a little more, because I obviously want to give as much time to the military as possible to get their ballots in. That's why I asked for the 14. I know we've been talking about 10, but I'd really like to see the 14 go through.
And that's half the time it takes for them to certify.
Yes, they have 28 days total, so 50% of the time.
It was part of your speculation that if they know how many have been requested, that isn't. I mean, why'd you pick 14 days? I guess is that 2 business weeks?
Yeah, it was just a number that I thought I'm trying to get as much time as possible for the people that are serving our country, and that was the direction I'm going.
Yeah, no. I think I voted for the bill before when it was 21 days actually. So I understand. I just wanted to see what your flexibility was on it. Great.
Any other questions? Yeah, my concern for this bill is that the 14-day time period for the return of ballots after election is too long. I have the same concerns as the election officials, and would compromise the integrity of our state's election. So last time when it was 21, I compromised down to 10 days too. And so I have 10 days. I think 10 days is a reasonable amount of time for us to get all the ballots back. And it prevents us from going into the third week. The 14th day will have us going into the third week.
Okay, well, we'll accept the committee's amendments.
Okay, 10 days. All right, great. All right, with that, I'm going to recommend support of this bill.
I move the bill.
Second.
Valadao.
Moved and seconded. All right. Motion is due pass as amended. Madam Secretary, please call roll.
Fong,
Aye.
Fong, aye. Logue, Bonilla,
Aye.
Bonilla, aye. Hall,
I guess so.
Hall, aye. Mendoza, Swanson,
Yes.
Swanson, aye. Valadao,
Aye.
Valadao, aye.
5-0. It's out. Congratulations.
Thank you.
Gordon. Assemblymember Rich Gordon with the badges, AB 481. Go ahead, Rich.
Thank you. Good afternoon, Mr. Chair and members. I'm here on behalf of AB 481, which relates to signature gatherers for initiatives. The analysis that you have from your staff notes authors' amendments, and I would like to take those amendments to apply the badge provision suggested in this bill equally to paid and volunteer signature gatherers. The Secretary of State suggested this change, and I agree. Anyone who has recently gone to the grocery store or a farmer's market is familiar with the initiative signature gathering process. This bill would allow an individual approached by someone to sign an initiative petition to know whether or not that individual was a volunteer who has a commitment to the issue, or someone who may still have a commitment but is being paid and compensated to advocate. I believe that this information will provide a more informed decision of those individuals as to whether or not they wish to sign the petition. The bill would provide the public with this greater immediate transparency in 2 distinct ways. First, the bill would require that an individual gathering signatures wear a badge stating whether he or she is paid or volunteer. Secondly, the bill would replace the existing requirement that a petition include a statement that the person may be paid or volunteer with clear disclosure at the top of the petition, noting whether or not the petition is being solicited through a paid circulator or a volunteer circulator. This bill would not prevent any individual from being compensated for signature gathering, and I do not believe that it would pose any significant burden on signature gatherers. Instead, this bill simply provides more sunshine on the initiative process, and I respectfully request an aye vote.
Okay, great. Thank you. Any witnesses in support?
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen, and with the author's amendments in strong support of this measure. As Assemblymember Gordon indicated, this measure will simply increase transparency in the initiative process. I would be happy to answer any questions and respectfully urge the committee's support.
Okay. Witnesses in support? Witnesses in opposition.
Thank you, Mr. Chairman. Members, David Wolf here with the Howard Jarvis Taxpayers Association. We're opposed to AB 481. And simply put, the Howard Jarvis Taxpayers Association has long been and is broadly opposed to any measure that we believe would inhibit the initiative system and the ability to collect signatures and qualify measures for the ballot. And contrary to the author's assertion, we do believe that the measure would do this. Listen, by requiring signature gatherers, whether paid or volunteer, to wear a badge, we believe represents kind of a scarlet letter situation, you know, where you are unfortunately targeting these signature gatherers, you know, who are being paid by just businesses in order to conduct a service. And we just we don't believe that's fair and appropriate, and we also believe it inhibits voters' ability to vote on measures that are important to them. According to the PPIC in a poll from 2 or 3 years ago, over 60% of voters want the ability to vote, you know, on measures that they believe are important to them. We just believe AB 481 would take away that ability to some extent. So for those reasons, we'd ask for a no vote. Thank you.
Okay. Any other witnesses in opposition? None? Any questions? Tony?
Mr. Gordon, I know that you already took some of the amendments here. My question, will now the badge that the folks wear, it will have the name of that they're either a paid person or a volunteer person, correct?
Correct.
Will they have the name of the actual person collecting the signatures?
No, it does not have their name. It just simply says volunteer, solicitor, or paid
Is it a good thing? Would you think it's a good idea to have that person's name on there or not?
Yeah, I think that personally, I don't think that that's necessary in terms of what the transparency I'm trying to achieve here. I'm trying to make sure that the public understands whether this individual is doing this in a volunteer capacity or a paid capacity. I don't think it's necessary for them to know who the individual is.
Okay, just sometimes when you encounter some of these folks, they get kind of pushy, or they get kind of, they tell you one thing, but actually it's another, and sometimes you don't know their name. I just thought maybe by having their actual name on there, say, yeah, you know, this guy, his name was Tim, and he was right there standing in front of the market, and then you'll probably, just a consideration. I just think, because I know that when I'm encountering them, sometimes you wonder, it's like, well, I know, but the average person might not know what they're trying to. You know, what can you read the fine print and you kind of maneuver your way politically. You kind of know how these positions work and how they operate. And sometimes these folks don't come off, you know, they're not being truthful. Some of the stuff that they're saying as far as the petition is concerned. So I just, maybe your consideration, I would maybe, I don't know how big, you still keeping to the 24 font?
Suggested 30, no smaller than 30 font.
Okay, that's fine. The bigger the better. But I do think maybe you should consider at least maybe their first name or something like that. As they could fill it in if they want. It doesn't really matter as long as they have their name on. Are you going to have the actual employer's name, the company that's employing them?
This does not include having the company's name on it, not who they're employed by.
Those two things I think are very important.
Yeah.
Well, if you're a paid gatherer, fine. Who's employing you? So then they will know who it is that you are dealing with and why you're circulating that. Is that something the committee is going to address? Or?
Yeah, the Supreme Court struck down on names. You can't put names down on the badge.
The person's name or the employer?
The person's name.
The person's name? Okay, name. But you can put the employer, though.
There's nothing. Court hasn't ruled on it yet.
Okay.
Lawyers. Part of the reason that we were concerned about adding anything other than just paid or volunteer is that there have been some First Amendment issues and court cases, particularly in terms of putting someone's name on there. The other thing is that as we looked at this, most of the paid signature collecting is done by a company or corporation, it would not actually help the individual identify who that is. If I'm working for, if I put on my badge, I'm working for, All American Elections. I don't know really who All American Elections is, who they represent. So it doesn't necessarily get you that level of clarity around, who's essentially funding that paid signature gathering, who's funding the initiative in that effort. It would require the individual perhaps seeing that someone says they have that they're being paid, to inquire and try to get further information. But because of some of the concerns around some of the constitutional issues, and because giving the name of the company may not really tell you very much, we decided to keep this very simple.
And I think knowing now that if we can ask them to put their name on there as far as who's circulating it, brings up to even more of a concern that maybe the company they do work for, because say that, like I said earlier, what if they happen to be a company that's not that reputable and are always saying one thing but the petition says another? At least you get to know, well, yeah, I remember hearing about you guys. Or you get to the guy that had talked to me in front of the supermarket, he came from the All American, campaign, whatever company. That might be maybe at least something that we can refer back and say, yeah, that's the same company that talked to me about that. You see what I'm saying? They create some sort of way of knowing who are these companies out there and who are the ones that are reputable and they're doing the job that the way it's supposed to, and when some that might be stretching it a little bit and not doing what they're supposed to. So I would highly recommend it. Maybe add a.
Our ledge counsel also informed that it might be unconstitutional to put the name of the company.
Might. We don't know yet.
Our ledge counsel ruled on that already. Made the recommendation that it might be unconstitutional, right?
Wow.
To put the name of the company.
Wow.
So that's why it's not involved. There's no name or name of the organization.
I don't know.
I know that you're good common sense, but the courts have struck it down on the name and our
name of the individual, but
our ledge counsel
company.
advised us that even the names of organizations could be unconstitutional to put on.
Could be.
Badge.
I would ask to put it on, but that would just be me.
Okay. David Valadeo.
As far as on the volunteer circulators, is there a penalty if they get caught without their volunteer badge on?
There's the legislation does not contemplate a penalty for either, as currently written. So whether they're a volunteer or whether they're paid, if they're not wearing it, someone in the public could inquire. This could be brought to the local elections officials, but beyond that, there's no immediate penalty proposed in this bill.
Who would enforce it?
I would note that the bill does have the support of law enforcement. The police chiefs have supported this bill.
So they would be the one enforcing the rule, then, the police officers.
Well, if I might, anytime there's any violation of the elections code, certainly the county elections officials office has the opportunity to investigate that matter further. Sometimes those violations get referred to the Secretary of State's office, and our elections fraud investigations unit may open a case and pursue an investigation. However, neither our office nor the elections officials office actually has the authority to move forward on certain violations for prosecution, if you will, when some of them actually, not in this case, but there are other violations that can result in misdemeanors or felony violations. Those get referred to the DA's office for prosecution in those cases.
Thank you.
Okay.
So isn't there already a disclaimer at the bottom of the petition that says volunteer or paid advocate or something like that?
Currently on the petition, there's language which says that you may ask the person whether they're being paid or volunteer. It doesn't state whether the person is a volunteer or being paid. This legislation would provide greater clarity by actually stating whether this is being collected by someone paid or volunteer.
So, but there is a disclaimer at the bottom of the petition that basically say you can ask the question, correct?
Correct.
All right. So isn't it doing basically the same thing, the bill?
Well, I think that
I'm trying to find exactly what it is you're trying to get out of this.
Well,
because you're not going to identify the contributor or the funding source on the badge. You're not requiring them to place your name on the badge. Then there is no fine associated to this bill if, in fact, the person chooses not to wear the badge one way or the other. So I'm trying to figure out the good of the bill. I'm just trying to get some clarity.
Sure. Let me make this argument, and that is that if you're confronted at the supermarket or at a farmer's market by someone collecting signatures, they've got usually several clipboards. They ask you to sign. Most of the public does not know to look for that wordage, the language on the petition that says whether you can ask the person whether they're being paid or they're a volunteer. This bill would make that very visible. It makes it visible by the person wearing a badge and by having language at the top of the petition very clearly stating whether this petition is being circulated by a paid or volunteer individual. I believe that what that does for the public is it provides them with an ability to make an informed decision that I think they have difficult doing now.
But Mr. Member, I'd be when I'm at I was at a grocery store just the other day, and I saw some people out there. Yes, I do grocery shop. Believe it or not. I was at, thank you, Mr. Swanson. Well, I was passing by a grocery store. Let's put it like that. No, just kidding. And there was a guy there with a petition. If he asked me to stop, at first I wasn't going to stop. Then I stopped. But I stopped. I stopped because I wanted to stop. And I didn't care whether he had a badge on that says volunteer or paid. I didn't care one way or the other. I made the decision to stop, and it's because I was interested in hearing what he had to say, one way or the other, and made an informed decision, one way or the other, to sign or not to sign. So I'm just trying to figure out the real purpose. If I was a paid volunteer or paid advocate, and I just happen to have on one that says I'm a volunteer, is there a penalty for that?
Well, again, it would be an issue that could be referred to the local elections officials for consideration under elections fraud.
Yeah, do you see my point, though? Because you say there's no penalty for not wearing the badge, number one. But then if I happen to be a paid staff person or advocate, right, and I decide to wear a volunteer badge that said volunteer on there, what recourse would there be for that? Will there be for that?
Well, it would be, as the Secretary of State's office said, the matter could be referred through the local elections officials to a district attorney for elections fraud.
Yeah, I'm a little concerned. I'm a little confused about this bill. I'm not really understanding the purpose.
Hi, Mr. Gordon. Do you see this as if this bill passes, would this increase litigation as far as registration and signing petitions go? Could you see that as a problem?
No, I don't see that as a problem at all.
Okay. How are you going to enforce it? I'm sorry, I'm a little bit late, but are you going to have the police enforce this? How are you going to enforce it? How do you plan on doing it?
Well, I believe that most of the enforcement will come from citizens who want to make a complaint, feeling that either the person is not wearing a badge, or they have some concern whether the badge is appropriately displayed, worn by the right individual. And those citizens would make those complaints to the local elections officials, to the Secretary of State, and if that led to an investigation of whether or not there was fraud, Providing fraudulent information in an elections process is a felony in the state of California.
Okay, do you believe that the state at this time has the resources to investigate thousands of potential violations because somebody doesn't wear a badge and say I'm a volunteer? Is that correct?
My position on this would be, Mr. Logue, that this is a fairly simple bill for people to comply with, and I would not anticipate major noncompliance. It's fairly straightforward, fairly simple. It provides a level of transparency to the voting public that I think is appropriate.
Thank you.
Yes. Thank you, Mr. Chairman. Thank you so much. So the simple purpose of the bill is to let the voters know whether or not a petition is being supported by a commercial effort or whether it's a volunteer effort.
Correct.
That's the simple purpose. And so following up on one of my colleagues' question, so if you're a paid volunteer and you say you're paid from company X, and it says paid volunteer company X, wouldn't that lead to maybe a more courteous petitioner, or it will allow some accountability if there was a problem? In other words, now there's a company associated, so it's Mike who's circulating petitions that's from company X. And so had you given any thought to that? I mean, I'm just getting to this question of transparency and accountability. And, the courts haven't ruled on that yet, but I'm just suggesting, wouldn't that add another level of transparency that would allow the voter a little more confidence?
Yeah, so, Mr. Swanson, if the individual was wearing a badge that said, paid solicitor, and the name of the company was under the badge, it absolutely would provide much greater transparency. And that's what we originally looked at doing with this bill, but were advised by Ledge Counsel that was fraught with some really serious problems, would clearly lead to lawsuits, and was probably not very defensible. Okay. So we tried to take, a course that would provide greater transparency to the public without putting us in jeopardy.
Okay, so you may come back after this. You may come back and get and try that bill separately. But I understand.
If we could get there, I'd get there.
I understand how that works. Okay, thank you, Mr. Chairman.
I was just wondering why do you suggest that we do the same thing for nomination papers?
No, I'm suggesting just this at this point for initiatives.
Let me ask you this question. If I'm a volunteer now and I'm getting signatures and I don't have the badge, am I going to be cited under your amendment?
You could be referred for election fraud. Okay. So it would, the volunteer is going to need to be aware that they need to have the badge.
So this is kind of my concern, and I think that your motivations are absolutely admirable. So I'm not questioning that. I'm just concerned about the logistic, how this plays out with the volunteers out in the state. If there's a constant problem with fraud accusations, just because somebody wants to be involved in the process might discourage people from being involved. I'm very concerned about this road that we're traveling. I think it's going to increase litigation quite a bit. I think it's going to put a damper on people wanting to get involved in the process, and I think we're trying to do just the opposite right now. So I'd be very concerned about this bill. But thank you.
Let me just comment that when initiatives are certified for the ballot, it goes through the process with the local elections official and Secretary of State. When before those are distributed for circulation, there's information provided to the organizers of the initiative effort. A part of that information would be clearly stating the requirement to wear this badge. So the volunteers would have that information in advance, and I think by providing that information, through the normal elections process. We would not be creating any additional burden for the volunteer.
Also, thank you for that. The other concern I have is on the internet, where you can actually sign signatures over the internet. What kind of disclosures will you have to cover that type of participation? Will this be covered also, or just somebody in front of a store?
That's not currently permitted under current law.
Right. Under current law, you cannot collect signatures for an elections petition initiative through the internet.
On propositions?
On propositions.
Thank you.
Thank you, Mr. Chair. And the reason I kind of asked some of these questions because I thought we were going to have the next bill by Mr. Wessel, AB 651, as a discussion because there were two bills that were very similar, but obviously he amended it, and now we have a different version of what he has, right?
Yeah, he's taking the badge out.
Exactly. So I wanted to, I was kind of looking forward to kind of either combining them or addressing that bill more so than yours because I kind of like that bill, but then now we don't have that bill, so now we're with this bill. So I'm trying to put some of the other bill into your bill to try to make it more appealing to, or for what we're trying to accomplish here. And I do think it needs to have a fine of some kind. I do think that, and I looked at the analysis for Mr. Wessel's bill, the original analysis. That council didn't say anything about if you put the employer's name as being potentially unconstitutional. It didn't say anything like that in the analysis. So for me, I don't think that's a real concern. The actual name of the petitioner, maybe you have a case there because I don't know anything about that. Mm-hmm. But as far as the name of the company, it didn't say anything as far as alleged council analysis on the staff report. So I for me to support your bill, I really would like to see some of the other language that was in Mr. Wessel's bill into yours, because I was going to support that bill or support both and see what which member like what. But knowing that his bill had been changed, then I think your bill would be probably much more better if we did have a fine on there and potentially the name of who's the company who's circulating it.
With the permission of the chair, I'd be more than willing to ask that this be brought back. Give us a week or two to work with Ledge Council to see what we can do.
That would be great
to resolve that question.
I mean, because I would if the Ledge Council said we can't do it, and for whatever reason, I want to know about it, and also because I think it's important to have the name of the company that's circulating to keep a track of which companies are reputable, which are not, who's doing an honest work and who's not, and that for our own and for the public to know as well. Yeah. And obviously, to me, this should have some sort of fine on there.
I think the briefing is in the Ledge Council's briefing is in the notes somewhere.
Yeah, but I think the author is asking for us to bring it back.
Right.
I'm willing to do that in order to provide further information, work with the Ledge Council to see whether some of these things are possible.
Yeah, Mr. Chair.
Okay,
that'll
bring it back.
Good idea.
Yeah.
Okay.
All right, thank you.
It doesn't have it on here.
Thank you, Rich.
Okay, thank you.
Thank you, Rich.
We'll be back.
I appreciate that.
Thank you.
All right, Bonnie Lowenthal. AB 362 by Bonnie Lowenthal. It's pass and retain, right?
It's just an author's board.
Okay. Okay, Bonnie, go ahead.
Thank you, Mr. Chair and members. AB 362 would modify the signature and declaration requirements of write-in candidates for Superior Court judge. Currently, if a Superior Court judge is running for re-election unopposed, their name is left off the ballot and they are automatically re-elected. Excuse me. A write-in challenge requires only 100 signatures, even in a county as big as Los Angeles. Worse, write-in candidates don't even have to show that they meet the constitutional requirements to hold the office. This flaw in the system came to light in 2008 when a known white supremacist took advantage of this low threshold to file write-in campaigns against 6 L.A. area judges with Hispanic surnames. This cynical harassment ploy was a waste of taxpayer money and election officials' time. AB 362 would stop that kind of mischief by increasing the signature...
Move the bill.
Second.
Moved and seconded.
Increasing the signature requirement to 0.01% of registered voters with a minimum of 100, which is the current limit, and a maximum of 600 required signatures depending on the size of the county. It would also require the candidate's filing statement to declare that they meet the constitutional requirements for the office of judge.
Witnesses in support.
Mr. Chair and members, Mike Belote for the California Judges Association. I recognize there's been a motion and second on the bill. The bill simply, this was passed last year, vetoed by Governor Schwarzenegger. We have responded to that by lowering the maximum number of signatures. We're not attempting to cut off people's rights to run and challenge a judge for re-election. As a matter of fact, it makes no change at all in the regular challenge of a Superior Court judge. It affects only the write-in, which is an unusual element in the judicial elections. We would ask for an aye vote, and I'd be happy to answer any questions that members might have.
Okay. Any questions? Witnesses in opposition? Any questions here? Okay. As the author points out, this process has been abused by individuals who had no intention of running a write-in candidate, but instead wanted to harass certain judges. So this is a great measure. I support it totally.
Thank you.
All right. It's been moved and seconded. Madam Secretary, please call roll.
Fong.
Aye.
Fong, aye. Logue. Logue, no. Bonilla.
Aye.
Bonilla, aye. Hall.
Aye.
Hall, aye. Mendoza.
Aye.
Mendoza, aye. Swanson.
Swanson, aye.
Swanson, aye. Valadeo.
5-1, it's out.
Thank you, Mr. Fong.
AB 651, Ben Wesso.
We should hold them.
Okay.
Thank you.
Chair, I'm not scheduling.
Thank you.
Thank
Good
you for
afternoon.
removing the badge issue, though.
Well, you know, I just wanted to let you know, in anticipation of this meeting, simply because we knew our colleague, Mr. Gordon, was working on the badge issue, we agreed to remove that, although there were some minor differences in how the badge is applied in our program, because initially we had an issue of a fine disclosing who the employer is, the badge listing the petition gatherer as a paid. We didn't apply our program to volunteers simply because we simply wanted to. In my mind, I feel if we require lobbyists to report, so the public, there's full transparency in terms of how information is being reported to in the process of making a law, that anyone paid in the process of gathering signatures becomes an interested party, and there may be a conflict of them, you know, getting paid to advocate for the citing of signatures, and this is where, in my own personal experience, the violations have occurred, where a gatherer is paid. Their motivation is to sign as many people to their initiative as possible, and oftentimes, you know, there's a little bit of misinformation. In fact, I have witnessed people gathering signatures on petitions based on false premises and false information. And I think if voters are willing to sign a petition, they should know what they're signing their name to. And we're trying to disclose as much. We're trying to include as much as disclosure as possible, so that there's complete transparency in this process. You know, in one process that requires representation, there's a lot of control. In petition gathering, there's almost no control, and our bill would require the paid firms, or the firms that get hired to collect signatures, to register with the Secretary of State and to be listed in a website. There will be a specific website for all petition gathering firms, and members of the public will be able to go onto the website and learn about who is circulating these petitions so they can learn a little bit more about the initiatives that are being put forth. There's been a lot of misinformation. We're just trying to correct that as much as possible. So initially, we had agreed to remove the badge issue because I know that Assemblymember Gordon is working on that. But initially, you know, we would have liked to see some of the issues that were raised. Legal counsel has raised the issue of you know, objecting to the potential non-constitutionality of listing the name of the people that are sponsoring or paying for the collection of the petitions. And what we don't want to see is where we pass something and be overturned in court, and that potentially throws the integrity of the law. We want to reform the process as much as possible, increase transparency as much as possible, and if we need to remove that specific provision, we'll agree to that as well. So,
okay. Great, thank you. Okay. Any witnesses in support?
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen. And with we have a supportive amended position, but as I understand the author's amendments that the Assembly member just took, the badges provision would no longer be part of the bill. Is that correct?
That's correct.
Most certainly in strong support of the remaining provisions of the bill that would require paid signature gathering firms to register with our office, and also to ensure that they are educating the paid circulators so that they're aware of all of the laws that they need to comply with. Happy to answer any questions that the committee may have and strongly urge the committee's support.
I'll move the bill, Mr. Chair.
Been moved and seconded by Sandra Swanson. Okay, any witnesses in opposition?
Mr. Chairman, members, thank you. David Wolf here with the Howard Jarvis Taxpayers Association, and we're opposed to AB 654 as well. I don't want to repeat the remarks I made during the Gordon bill, and I understand, of course, the bill's been substantially amended, but just to make a couple of additional points. Number one, we do believe the fine authority does represent increased government intrusion in a private business, and for those reasons, we continue to be opposed to the bill. And also, let me just make a point real briefly just about the element of personal responsibility. And in this, I agree with Mr. Hall's comments earlier, just in regards to the ability to sign petitions or not. When I approach signature gatherers in grocery stores or farmers markets, I actually request to read a copy of the initiative. And I read it fully because I want to make sure I'm not being lied to and I'm not signing, let's say, an oil severance tax, for instance.
You wouldn't do that.
No, of course not. But members, that's just it. It's the element of personal responsibility. You can stop, you can read, you can ask the petitioner who they work for and what petition, you know, they're presenting. And if you're not happy with the answer, you don't have to sign the petition. And so let's just not forget that element of personal responsibility. For those reasons, I'd ask for a no vote.
Okay. Tony Mendoza.
And according, you're not touching the badge issue on this bill, right? Now we're looking at creating a website, putting they have to file with the Secretary. This is different from what you're talking about. But I think you're actually logging now and actually tracking these companies that are actually doing these signature gatherers to find out whether they're legit or not, if there's any complaint logged against them, and all that, which is great. That's the great thing about the bill. The whole concept you're talking about is going back to the badge issue, and I think we'll agree to disagree on that, but I think this is where this bill is very valuable. I think they kind of, they're two separate ideas sort of, but they kind of overlap a little bit. I'm hoping that Mr. Gordon, when he comes back, will have something where I think we'll all be okay with. But as far as this bill, Mr. Chair, I think it's a great bill. Thank the author for bringing it forward, and I think it's a great start to ensure that we have good, legitimate folks out there working, and we'll know who are the bad apples and the ones that are good. So I think we should support.
All right. Any other comments? Well, I believe this requirement for petition firms to register with the Secretary of State and properly train their employees will go a long way in deterring future fraudulent practices. Like I've supported in the past several times in this committee, I'm a strong supporter of transparency, and yours really provide for that. Thank you. So the motion is do pass as amended and refer to the Appropriations Committee. Do you wish to close?
Just want to thank you. Would thank you in advance for your support. And there are actually a significant amount of incidents where there are complaints lodged by the public, and I want to ask the representative from the Secretary of State's office to maybe share some of those figures with you, just to give you an idea that we're not just simply.
Mr. Chair, are we closing? Are we closing with the author, or?
Yeah, well, it's a close.
Okay.
It's just closed.
Is it appropriate that I ask the
Well, I
Secretary?
think there was a motion and second, and
Yeah.
you're closing.
Okay.
Right.
It's closed.
Well, I humbly request your aye vote in this matter.
All right, thank you. All right. Madam Secretary, please call roll.
Fong,
Aye.
Fong, aye. Logue, Logue, no. Bonilla, Bonilla, aye. Hall, Hall, aye. Mendoza, Mendoza, aye. Swanson, Swanson, aye. Valadeo, Valadeo, no.
Thank you, members.
Okay, thank you. Thank you, Ben. Congratulations. It's out. All right, prior to obtaining a quorum, the committee heard from Assemblymember Yamada on AB 413. Ms. Yamada agreed to accept the proposed amendments that are outlined in comment number 4 of the analysis. I'm recommending a support.
I move the bill, Mr. Chairman.
Bill has been moved. Is there a second? Second. Second by Ms. Bonilla. All right. Madam Secretary, please call roll.
Fong,
Aye.
Fong, aye. Logue, Logue, no. Bonilla, Bonilla, aye. Hall, Hall, aye. Mendoza, Mendoza, aye. Swanson,
Watson, aye.
Swanson, aye. Valadeo,
You'll-
Valadeo, no.
It's so hard for you to say yeah.
He'll say aye in this one. We also heard from Assemblymember Knight on AB 193. Mr. Knight accepted the author's amendments outlined in comment number 2 of the analysis. With that amendment, I'm recommending support on the bill. Is there a motion? Moved?
Second.
And seconded by Mr. Swanson? Okay, great. Madam Secretary, please call roll.
Fong,
Aye.
Fong, aye. Logue,
Aye.
Logue, aye. Bonilla, Bonilla, aye. Hall, Hall, aye. Mendoza, Mendoza, aye. Swanson,
Swanson, aye.
Swanson, aye. Valadeo, Valadeo, aye.
Oh, he said it. And that didn't hurt, did it?
More than you know.
Okay, that one is out too, 7-0. Mr. Knight's bill is out, 7-0, and
Leave the roll open
Come on.
for 2 minutes.
We'll leave the roll open for 2 minutes to add on.